This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi everyone, welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed, and we are reading through the Menendez brothers' retrial, which took place in 1996. First trial took place in 93. And they are on trial for the homicides of their parents, Kitty and Jose. It is a death penalty trial. You may or may not remember that. We are currently in the guilt phase. So we're in the defense's case right now, which we're on 76 and there's 92. So we're getting closer to the end of the defense's case. We'll have some rebuttal evidence from both sides, and then we will have closings. Then we are also going to go into the penalty phase after we complete this, which is the death penalty. Do they or don't they get it? We know, spoiler, that they don't, which is awesome, but they do get life without parole. We know that's changed now, but we're taking a look at this case through the lens of we know better, we know more about abuse now, whereas it was knowledgeable in the field, like within psychology, but it wasn't necessarily taking place in the court system yet, where it was like, okay, there's abuse in this family, so there's possibly reasons why that person might have committed a crime against their abuser. So that's why we're looking at this case, because I think it is important. And I also think that they were way over sentenced. So, with that being said, let us get started. I do want to first thank our founding Justice Insiders and our Justice Insiders. So, if you joined before the deadline on June 30th, you were able to become a founding Justice Insider. That is your title forever and ever more. And if you missed that deadline, it's okay. You can still become a Justice Insider and get just about all of the same member perks. It's just you don't get the founding Justice Insider title, unfortunately. So let us thank our founding Justice Insiders: Toyota Girl 67, SLB 29488. May the force be with you, 4313. Jessica Wienand, 6079. As you can see, I've updated this and everybody's names are on the video that's looping. Mrs. Apples, 2007. I think I always call her Ms. Ms. Apples? It's Mrs. Apples. It's MRS Apples with a Z. And then Butler, 89833. Brooke JF, Jen P 773, who I saw in the chat. I think it was in Defense Diaries. So shout out Jen P. I saw you in the Defense Diaries chat the other day. Boom Chicka Wow Wow 1, Kendall B 5757. We also want to thank Carly 0406. Oh, Ashley 83. True Crime Debates, Sandy South 5706, Chickenhead 33, and I'm going to struggle with this name constantly forever. Nicoti Nerotini, something like that. That's So Nelly, and that so is spelled SEW, like a sewing machine. We have Julie E 6770, 1-800-Fraudsters, Bezo Jones, and Hannah Banana Bandana 23. Those are some fun names. And then we also have Laney Jane 91, Couch Potato Pro. I like that one. And then Tech Vibe _42. Thank you for being Justice Insiders. Those three, Laney Jane, Couch Potato Pro, and Tech Vibe 42. You are also very much appreciated. All of you, anyone tuning in is very much appreciated. All right, let us now get to it. Okay, so I gotta switch my screens. Hold on. So before we get reading, just want to remind or warn you, I should say rather, as I have been warning you, now that we're in the defense's case, the state is basically objecting to just about everything. So whenever the defense wants to bring some kind of abuse evidence in, it mainly has to do with the abuse. Anything that has to do with Kitty and Jose being abusive parents, the state does not want in. So everything, and I mean, just about everything has become a battle, and we're constantly taking breaks and having arguments outside the presence of the jury. That's where we're going to start. And then we're going to conclude with, um, uh, at least today's episode, we're going to conclude with a continuation of Dr. Wilson's direct examination. If you recall, he was on the stand earlier in this week. So this is Friday, January 19th. So earlier in this week of January, he was on the stand. So I think Monday, maybe even Tuesday. And then we had arguments. We had a bunch of other witnesses in between. We had a bunch of breaks for arguments. And now we're back with another break for arguments. And then we're going to go into Dr. Wilson's direct testimony once again. All right. So the following proceedings were held in open court outside the presence of the jury. The court says in the trial, the defendants are in court with their lawyers. The people are present. The jury isn't here at the moment. Yesterday, I had asked counsel to review the proposed testimony of Dr. Wilson in conjunction with the people's motion to limit portions of the proposed testimony to see if there were those things that can be brought up before the jury that aren't subject to people's objections, so we can start with the jury without a hearing at this point. Are you able to do that? Ms. Abramson says, well, Your Honor, frankly, after reading the people's motion again, reading some of the cases that they cited, and looking at the line of questioning that was objected to, we were not doing anything in violation of the people's motion. The people, in Mr. Khan's objections, were completely contrary to the position the people took in the motion. What? So the things Mr. Khan was objecting to wasn't even what he was talking about in the motion, or is actually the opposite of what he was talking about in the motion? He was objecting to my asking questions about general behaviors within the context of incest perpetrators and their victims, not even in the context of something like the child abuse accommodation syndrome, which I never used and was not involved with and wasn't being presented as syndrome evidence. But he was asked about what the research indicates is the general behaviors, which is precisely what the court says what the courts say you cannot, or you can get into if the victim's abuse you can get into the abuse if the victim's credibility has been challenged, which it certainly has in this case. And Mr. Khan was objecting that it's irrelevant what happens in other cases and that it should be case specific. In his motion, the objects to the witness coming up with case-specific conclusions that the defendant was in fact molested, or that the behavior, I would assume, of the molester in this case, or that the behavior of Mr. Menendez made him a molester. So I thought I was proceeding within the context of what I understand of the case authority on, first of all, I don't believe the case cited by and largely really applies when we are talking about a defendant's mental state in a homicide case. I think the only cases we can look to as to how syndrome evidence is admissible for mental state is Eris and Day and those cases. What the people are relying on is a huge amount of cases dealing with the R word trauma and child abuse syndrome, where the trier of fact was to determine one issue only, which was that the child was molested. And the testimony of experts that there is such a thing as this syndrome, and in effect that the child meets that syndrome, was usurping the function of the jury. That's not what we're doing here. It has long been understood that the particular rule does not prevent a criminal defendant from using syndrome evidence if it explains his mental state at crucial times. So, isn't that exactly what we're doing? So basically, her argument is, and this is what she's saying, is they want to bring in these other abusive acts by Jose in order to contribute to the mental state at the time, which is what I've been saying this whole time, is that it all compounds in your mind. You can't separate the two. Just because it happened when you were 5 and then when another thing when you were 12 doesn't mean that it didn't affect you when you were 18, making the decision that my parents are going to kill me and I have to get to that door first before they kill me. It doesn't, all those things don't go away because they're in the past. They all compound and make you even more afraid later on. And that's basically the point and the reason why it should come in. She says the actual time of the crime and any other period of time that the prosecution has put in issue, as they have in this case, concerning behavior of the defendant, which such behavior is explainable in terms of syndrome evidence. So his behavior can be explained by this child abuse syndrome or whatever, whatever you want to call it, whatever you want to label it. He was abused, and that will lead to this behavior later in life. So the people say in their motion that what the defense should be limited or yeah, what the defense should be limited to doing is this is page 18, line 5. Quote, we ask that the experts be limited to testify that they relied upon the reports of the defendants concerning abuse because they are consistent with the person having been abused. End quote. Now, I am just trying to lay the groundwork for what is the body of literature indicating certain behaviors and expressions and emotions and reactions of people who are abused. Particularly, I was focusing at that point on sexual abuse, and not only to explain the witness's ultimate opinions and conclusions, but to rebut the challenge to my client's credibility, where he was flat out accused in cross examination of making it all up out of whole cloth. So, not only should this come in for state of mind, but it should also come in because he was challenged by the prosecution in his cross examination, basically making it seem like he's making all of this up. That's how some of his questions came off. And that's another reason why this should be able to come in. She says to show that these kinds of things that he talked about are typically reported by abuse victims in the literature. It doesn't establish abuse, but much of what he said are known effects of abuse, and what he said is typically of patterns of incest families. Now, that doesn't run afoul of any of these cases that the people cited. I always intended to do that way. I do understand section 28 and 29 and the rules of ultimate opinion of the evidence code, but the people can't have it both ways. They can't say we can't talk about the general fund of knowledge in the field on the one hand, and we can't have ultimate conclusions about the defendant on the other hand. Then there is no point in challenging an expert. Now, I should indicate that based on the people's cross examination of my client and based on the typical way in which prosecutors approach defense experts, and based on the DSM 4, which we're on the 5 now, but at this time they were on the 4, we're going to have Dr. Wilson talk about the concept of malingering, what it does mean and what it doesn't mean. So basically, if you're faking your symptoms of abuse, he can tell. He can provide a conclusion on that, or an opinion rather, um, and explain what it is and how, as he is directed by the DSM-4, he dealt with that issue in this case. Now, with maligning. Now, he is not going to offer an opinion. He is not going to say, I believe Erik Menendez told the truth. I believe Erik Menendez is truthful. My opinion is that he was in fact molested. We never even offered those opinions in the first trial. The prosecution brought them out with respect to my witness, Dr. Burgess, in their examination. I mean, I do know how to do this within the confines of the rules, and I don't believe that I stepped anywhere over the line in the examination that appears on pages blah 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 for a couple of pages that were being objected to by the people. But clearly, there is, in any kind of expert opinion on mental state, the expert has a right to indicate the basis of their opinions and a right to bolster or at least point out what it was they found reliable about the information upon which they are relying, why they obviously, I mean, it's obvious, they have to accept it on some level. I think that most legitimate experts would say is that they can only evaluate what's before them based on their experience and the research. They cannot say absolutely something occurred. They could always be wrong because there is no magic for for truth telling, and I am sure that that's just as true with Dr. Dietz as anybody else. They can't make a foregone conclusion, yes, this person is telling the truth, or yes, this person is lying. They can offer an opinion and say these things that this person did are consistent with maligning or are inconsistent with maligning. Do you see what I'm saying? So it's an opinion. It shouldn't be, he should be able to express his opinion about it. It's not like it's set in stone. He's not putting it, in concrete language, definitive language. Ms. Abramson continues on and says, but the point is, that doesn't mean they can't indicate that they did form opinions, that the information that they are basing their ultimate opinions on was worthy and supportive of their opinion. Otherwise, there would be no way to even have an expert testify to any kind of mental state diagnosis, even legal insanity. They are always relying to some extent on these statements made by the patient and the manner in which those statements are made, the content of the statements, and the manner of report. The content of the report, just within the confines of talking to the person, apart from corroborating information, has to fit within the framework of what's known about the symptomology. Sorry, it's my dog moving my whole table here. He wants more. He's really stretched out on my legs. He wants lots of room. You can see his legs here. Sorry for that. I forgot where I was. Okay, so the content of the report, just within the confines of talking to the person, apart from corroborating information, has to fit within the framework of what's known about the symptomology of certain illnesses and how people report them and what's maligning style of report versus a non-maligning style. In those cases, with respect to so called diminished actuality, they are entitled to offer an opinion based on the hypothetical identical with facts. In this case, that if a person suffered from thus and such mental infirmity in this and such a situation, hypothetically, they did not intend to kill, or they did not harbor malice, or they did not deliberate or premeditate. So we don't intend to violate any of the rules of ultimate opinion. But I would point out that I don't think that the cases that the people cited, most of the cases, are of much use in this regard because they don't have to do with mental state of a credibility challenge of the defendant in a homicide case. They have to do with having an expert use these clinical syndromes as proof that a particular child or a particular alleged R victim was, in fact, molested or R'd, and we don't have any intention of doing that. The court says, okay, Mr. Khan? Mr. Khan says, yes. I think that counsel is doing precisely what she claims that she is not doing. Well, that's a good way to start out arguments and, not have hostility. She wants to backdoor the issue of whether this witness can testify that, in my opinion, this particular person was in fact sexually abused based upon the following criteria. And she knows from the case that I cited, the Bowker case, that she cannot do that. She cannot do it directly by taking testimony from the witness, establishing that it has opinion, that his opinion, this person was, that in his opinion, this person was sexually abused. I can't talk. She cannot do it by taking testimony from the witness that that he evaluated the behavior of the defendant in light of the sexual abuse accommodation syndrome, the child sexual abuse accommodation syndrome, found it to be consistent and used that criteria to determine that the defendant was in fact sexually abused, and she cannot do it by simply throwing out that criteria, floating the criteria, to quote one of Mrs. Menendez's favorite words, floating that criteria in front of this jury so that they can pick and choose and play psychiatrist and apply the criteria that they think establishes the elements of the child sexual abuse accommodation syndrome to prove that the defendant was in fact sexually molested. And Bowker specifically addressed the danger of doing that. It said that the jury is not qualified to do that if the expert himself is not permitted to use that criteria and reach a conclusion that the defendant was sexually molested based upon that criteria. It is all the more harmful to float that criteria in front of the jury and have the jury do precisely the same thing by putting two and two together. So we ask, although counsel is talking about what she is going to do and not going to do with this witness, and I think it is all very vague at this point because we don't know exactly what questions she's going to be presenting to the witness, and the only time will tell when she intends to accomplish with this witness, and we can't perhaps at this point rule on every specific issue that is addressed in my motion because we don't know how far she is going to go with this witness. At the very least, the issue before the court at this time is in regards to the witness testifying in certain people evidence concerning the abuse relationship so that the jury can note the characteristics of how it normally occurs and take the testimony of Erik Menendez and put two and two together and reach the conclusions that Erik Menendez was in fact abused based because after all, Dr. Wilson said that when someone is abused, you observe certain patterns of behavior, and those patterns are present in this case. Whether or not we call that the child sexual abuse accommodation syndrome, that's a long title to have to keep repeating, or whether we call it something else, that is precisely what he is doing. He is saying that there is a body of knowledge out there which says that these particular patterns of behavior establish sexual abuse, and we are inviting the jury to improperly apply the criteria for the purpose of determining that the defendant was sexually abused. So I think that the witness has already indicated to this jury the basis for his opinion, and he should not be permitted to go further into specific profiling criteria for the purpose of establishing that the defendant was sexually abused. I think it also, the fact that he was, if knowing that he was, puts it into context too that Jose would not stop. This Erik was a man. He was 18 at that point. Yet still very much childlike because of how stagnant his development became because of all of the abuse that was surrounded him at the age, usually like when you have something so traumatic, especially the severe trauma that these two experienced growing up in that house, it makes a permanent mark on you. You are shaped by it, and it affects everything about your development as a person, like your own self-worth and self-being. That is all developed during those years. And if you have abusive parents telling you, I wish you were never born, what do you think your self-esteem is going to be at that point? You're not going to think very highly of yourself. You're not going to, and if your parents do everything for you, like do your homework for you all the time, and they don't really give you the opportunity to like go and be free and do anything for yourself. They've got your schedule regimented every second of the day. You're either in school or you're playing tennis or you're going swimming or whatever it is. They have you doing something, whether it's against your will or not. Your whole day is planned and you become accustomed to it and you just go with the flow. Mostly, especially Erik. If you listen to his testimony, he tried not to cause waves with his father. If, he thought he was pissing his dad off, he would back down or cower or whatever. He didn't want confrontation to happen. And that's what a lot of people in the households with abuse do is they cower and they don't know how to respond. They freeze in the moment. They don't know how to deal with it. And yeah, you become very in tune with your parents or your abusers' behaviors at an early age, very early. Sorry, I went on a tangent there. The court says, what did you mean then in your reference on page 18 of your motion? We asked that the experts be limited to testify that they relied upon the reports of the defendants concerning abuse because they are consistent with a person having been abused. What did you mean by consistent with a person having been abused? Mr. Khan says simply that I believe that he can state that he relied upon criteria which has been noted in the literature to be consistent, but not to establish abuse without specifying that criteria. Once we run into a specification of that criteria, then we are running afoul of the case law, which says that that criteria does not establish sexual abuse. I'm okay with that. Let's create some kind of criteria or something to specify, what that entails, what abuse entails. Um, he says, I don't think that he should be able to suggest to the jury that criteria proves sexual abuse. At most, to give the basis for opinion that court may allow the witness to make brief reference to the fact that there are criteria which is consistent with abuse but which does not establish abuse, and the court has to strike a balance as to where the expert is permitted to go from there. If the expert is permitted to spend, if the expert is permitted to spend an enormous amount of time going through that criteria for the purpose of suggesting to the jury that that criteria establishes sexual abuse, it runs afoul of the case law. Ms. Abramson says, Mr. Khan is asking this court to ignore Eris. That court made it very clear that so-called common misperceptions about the behavior of the abuse victims and abusers is admissible. The same language appears in Bowker and the other case they cited. When the victim in those cases, when the victim's credibility was challenged, the general components of that syndrome were held to be admissible to dispel common misperceptions about the behavior of molested children, and that's in a case when it's being introduced by the prosecution where the courts have tried very hard to limit the range of admissibility of the syndrome. We would suggest that when it's being introduced by the defense to explain a defendant's conduct that has been attacked by the prosecution and that it commonly is misperceived by the public, that Eris and Day and the other cases made it clear that it is admissible. The people cannot dictate that our expert only say it's consistent without demonstrating in what aspects it is consistent because it wouldn't even be accurate for him to say or ethical for him to say every single thing my client told him is consistent with abused children. That doesn't happen to be true. There are some things about which there isn't a body of knowledge to measure consistency. The issue is what are the components of his behavior, the acts of him and the behaviors that he reports by his father that are consistent with patterns of incest families. Now, to say consistent with makes it obvious you are not saying therefore incest occurred, you are only saying that that's what he's hearing. What the expert is hearing did not rule it out and was specifically reliable for him to base an opinion on. Now, Mr. Khan may not like the fact that Erik Menendez demonstrates symptoms of PTSD based on the sexual molestation, might not like the fact that the history that he has given over the past 5 years is consistent with the history that other molested children have given. But the fact remains that that's how he talks about it, and we believe ultimately the fact is he talks about it the way or that way because it happened. He talks about it in a genuine way in which someone who has truly been abused would discuss it. They relive that trauma when they talk about it, and you can often tell. And I think when we watched the first trial and Eric and Lyle were on the stand, I felt like they were reliving that trauma again. I feel it was some moments were very emotional, very powerful, and Eric had to do it a second time. Lyle kind of fortunately lucked out only because, issues arose with his trying to convince other people to say that Jose was abusive with them, only to protect his dad's image of the sexual abuse and to not admit it. He was having issues himself admitting that the sexual abuse took place, or he didn't want to talk about it. Rather, he wasn't dealing with it well. So we go on to say, we don't believe that it is in any violation of the rules of admissible evidence that because he talks about it in a way that's consistent with the way other children who have been abused talk about it, either as children or as adults, that may be circumstantial evidence that it happened. Indeed, it is because we believe it did, and that's just the reality. That's as if they were objecting to someone being diagnosed as schizophrenic because he has schizophrenia. But if you demonstrate the symptoms of schizophrenia, that supports your statement that you have it. Mr. Khan says, I think that counsel is Miss Emerson says, I mean, let me just say one other thing. Otherwise, there is no way to understand what the language in Bowker and in Eris and in other cases is about. The right to use syndrome evidence to explain common misperceptions, or the right that Eris indicated that the expert they should have been permitted to testify that Ms. Eris suffered from battered woman syndrome and how that syndrome could have affected her perceptions of imminent danger. Exactly. The same, very, very, very similar to this case. Her having suffered this battered woman syndrome could have, or now it's spouse or whatever you call it nowadays, that was affecting the way that she perceived things around her and made her feel like she was in imminent danger. It's the same exact thing that happened with the brothers. They've explained the tensions were so high that week after Erik told Lyle. Lyle confronted Jose about the abuse. Jose said, screw you, I'm going to do what I want. And the rest of that week was very, very tense and didn't really get along or talk. There were blow-ups between Kitty and the boys, and eventually, we know that it led to them feeling that night, that Saturday or Sunday, what was it, Saturday? That Saturday night when they shot their parents, it was out of fear because of all the abuse that they've suffered along the way. It made them feel that they were in imminent danger because they know how to read the cues from their parents. You do it all your life. That's part of the hypervigilance. You can read your parents' cues. Is your parent anxious? Is your parent happy? Is your parent angry with you? All of those things, right? So you try to determine that before your parent enters the room because you're bracing yourself for, am I going to get yelled at today? So it all stems from that, like, fear and anxiety and not knowing what's going to happen next. And it can build and build and build and make you think that that person is out to get you, perhaps. And in justifying that opinion, the court may recall the testimony, the statements of the court of appeal in that case, if I remember it correctly, went through the whole cycle of violence theory of battered women's syndrome and building of tension and the erupting of violence, and then the loving contrition of the batterer as typical of battered spouse behaviors and relationships. And there was no objection to that evidence coming in. So something about the cycle of violence, how the man, the abuser, the batterer, was abusing this woman in the Eris case, and it was building, and then it would erupt into violence, and then he would say, "I'm sorry, I love you," and shower her with gifts and all the things that he does, and then she forgives him, takes him back, and then it starts all over again. That's the cycle. And it is precisely, did I finish that sentence? I don't remember. I mean, that evidence came in even in the trial. That evidence was held by the Court of Appeal to be admissible, she says. And it is precisely that type of evidence that was being objected to here when I was talking to Dr. Wilson about patterns of behavior. Mr. Khan says, I think that counsel is citing from the Eris case improperly. The Eris case, of course, I always think it's the Arias every time I see it spelled out. Eris. I think it's Arias. It's like Jodi Arias, but it's not. Um, so the Eris case, of course, involved a situation where the fact that the woman had been battered was clearly not in dispute. Numerous witnesses testified in Eris concerning the history of battery upon the woman. And so, where the evidence or the facts of the battery was not in dispute, there was little harm in allowing testimony concerning the battered woman syndrome because the so called trauma in that case was not in dispute. This is a very different case. We all know the trial is radically different from Eris because the fundamental dispute in this case is whether the defendant was ever molested by his father. Now, they want to bring in a witness to say, well, I accepted the fact that the defendant was in fact molested, and I accepted it for the following reason. And they know precisely what they are doing. We all know what they are doing is using the expert to establish the fact of molestation. But good. Yeah, you should use an expert for that. Not to, I mean, they're not establishing it. They're saying that it's probable, it's more than likely. The evidence points very clearly to Jose and Kitty were monsters. So there's that. And that is the critical difference between the case and the Eris case. So here we run into the problem of how to avoid the people after being prejudiced from an expert getting up there on the stand and giving various profile evidence to establish for this jury in a pseudoscientific way that the defendants were in fact molested, when in fact such profile evidence has never been accepted by the courts in this state before. I cite in my motion the language from Eris distinguishing the Bledsoe and Bowker situations, which is more akin to the case in the Eris. Eris distinguishes Bledsoe and Bowker, saying that there is blood in Bledsoe and Bowker. Those cases involved certain situations where it was at issue as to whether or not the defendant had been AR'd or abused. Those opinions held the evidence inadmissible unless they could satisfy the Kelly-Fry test, which they did not, or could not, because child sexual abuse accommodation syndrome and the R trauma syndrome were not developed for the purpose of proving that the crime had occurred. This is the language from Eris. Eris goes on to say, in contrast, the battered woman syndrome testimony in this case was not offered to prove that the defendant had been battered, but to prove that the defendant generally perceived imminent danger and the need to kill the victim. So so then why can't they put it on? They should be able to put on evidence that shows that they were generally perceiving it to be violent. So the question then becomes, just because defense counsel says, well, we're not offering it to prove that the defendants were in fact molested, we're offering it for the same purpose that it was offered in Eris, just to show imminent danger. But we all know that here the danger of such evidence is very different from the situation in Eris, and for that reason, special safeguards have to be taken here. We are also dealing with the other with opinions which have never been recognized to be admissible in any court in this case, or I'm sorry, in any court in this state. And we are dealing here with a post-traumatic stress disorder, which includes as one of its elements a stressor, and we just leave it up to the expert to find whether that stressor really took place or not, when in fact that may be the key issue of the case. So I would ask once again that the expert in this case be precluded from giving profile evidence that at most is a basis for his opinion. He can indicate that he relied upon this statement of the defendant, the psychiatric test that he relied upon, if anything, concerning the literature. He should not be permitted to go further than to say that there are characteristics of abuse that he found to be present in this case without delineating those characteristics for the jury. We ask that that balance be struck because the focus in the case is not so much what caused the post traumatic stress disorder, but the effects of the post traumatic stress disorder. This is the focus, and where do we draw the line? And if we allow this expert to get into a specific laundry list of symptoms that he found to be present, which are consistent with the person who has been molested, he is running afoul of Bledsoe and Bowker. Ms. Abramson says, Your Honor, I just want to. I am sorry, counsel, are you through? Yes, says Mr. Khan. Ms. Abramson continues. Your Honor, with respect to Eris, I think counsel read something into Eris which the case doesn't have and would establish a rule which would allow prosecutors to defeat any admissibility of battered person's syndrome or battered woman's syndrome in any case. He could simply cross-examine the woman and say, no, he never battered you, and you could never get it in, according to Mr. Khan's construct. There is nothing in the Eris case that says the battering is without intention, and there is nothing that takes it into account. What the case specifically says with respect to Bledsoe and Bowker, where the syndrome evidence was being used to try to establish through syndrome analysis that the crimes of R or molestation actually occurred. And the reason it wasn't admissible in those cases, which is very obvious from the cases, is that there is no science in the development of those syndromes that would be sufficient to indicate that anybody exhibiting those behaviors, IPSO facto, was ARD or molested. We're obviously not depending on either post-traumatic stress disorder or battered person syndrome here to establish that my client was molested. We are defending him, or we are depending on him for that purpose. Sorry. But what Eris went on to say is that BWS testimony in this case was not used to prove defendant had been battered, but to prove that the defendant generally perceived imminent danger and needed to kill the victim. Now, first of all, it is obvious that the time you put into the testimony that the Court of Appeal said was admissible in Eris, which is that person is suffering from battered person syndrome, you are proving they are battered. The point is that not ultimately the issue in the case, and that's not the purpose for which it's being offered, because I don't care. I don't care about any of this. Let's get to the point. If the jury believes Erik Menendez was molested, that still doesn't mean that his mental state at the time of the crime was such as to reduce the murder to a manslaughter. That's an additional set of issues. So maybe they would reduce some reason to reduce Erik's Erik's case or sentence. I don't know. Anyways, so it's not the ultimate issue in this case in any event, and for what it's worth, a number of the jurors in the last trial who were voting for murder nonetheless believed he had been molested. So, counsel, of course, has his own theory, tactically and otherwise, about what the case is about, but that is not the ultimate issue in this case. Nonetheless, we are sorry, I lost my place there for a second because I was moving the page and reading at the same time. My eyes are going wonky because it's 45 minutes in. It's about that time. So, nevertheless, we are not offering an ultimate opinion by the expert, a bailiff, in fact, in that, but he has to justify why he believes that post-traumatic stress disorder was the result of sexual abuse. The Eris court goes on to say the testimony of battered women's syndrome or battered wife syndrome, whatever, is expert testimony as to the defendant's state of mind at the time of the killing and is indistinguishable from identical notes or identical types of opinion testimony in the context of diminished activity. So basically, am I reading that right? So if your expert, if you're dealing with a battered spouse or an abuse victim, basically they are your expert in it too, because they're the ones that went through it. They're the ones that have to tell you about it, and it has to do with their state of mind. So I don't know, interesting kind of way to think about it. Now, that's the actual portion of the heiress discussion where they dealt with the quote Mr. Khan was referring to, but that is also the portion of that option that talks about the admissibility of this to dispel common misperceptions, and the people had conceded a year ago, maybe more, that the evidence was admissible for that purpose. That's what I'm aiming at in this line of questioning is common misperceptions about the behavior of abused or molested children because my child's behavior in that regard was severely challenged repeatedly. When the people say that the evidence should be limited as they do in their motion to merely the motion of the homicide, they forgot cross-examination, of course, hadn't been done at the time that this motion was written, having to do with my client didn't leave. Exactly what the battered woman are always asked, why did you leave? People, so battered women are always asked, why did you leave? Hold on, I need a footstool. My hip is killing me. I'm trying to I'm trying to drag the footstool over or the ottoman over with my toes. I need to stretch out my leg. I got my hamstring tear. This has been going on since like February or March. I tore my hamstring and it's still killing me. Um, Back to testimony. Dr. Wilson, or I'm sorry, I think this is who's talking here. I think it's Mr. Khan, right? I forgot already. Who is it? It is Miss Abramson. Okay, so she's going on a rant here. So now she's getting into. Sorry for wasting your time there for a second. So now she's getting into why are abuse victims always asked, well, why didn't you just leave? Because this was asked of Erik Menendez about 5,000 times on the stand in his 7 days that he was on there by the prosecution. And the same way that he questioned why people lived in the house, if it was so bad, why didn't you leave? Why didn't you report it? How bad could it have been? So, really, that's all I was trying to do is ask threefold. Number one, to show the basis for the expert's opinion. Number two, as rebuttal to the allegation that my client is lying about the molestation because he did not act in a way that Mr. Khan wants the jury to believe he should have acted. And number three, to dispel common misperceptions about how abusers and abused children interact. And there really aren't. I mean, I think I asked him three questions which were objected to, and pretty much that was it on the molestation front of where I was going or what I was going to do. The court says, well, what were those three questions? Ms. Amerson says, let's see. One appeared at line 46, 190, and 12. Now, this is being asked if in a fairly leading way. I might ask it more open-ended. Question: as children get older, is it reported in the literature that as incest victims get older, their abusers tend to increase the level of threats and effort to control because they fear the child might be more likely as they get older to report? So the older you get, the more likely you might report your abusive parents to the police, or maybe not the police themselves, but to somebody that It's a trusted authority that would report it on your behalf. Um, and that was objected to twice, 3 times. With respect to the next question with respect to the literature concerning children living in abusive relationships within the home, is there an escalating pattern that's been known of fear-inducing behavior by abusers? Objection sustained. She goes on to the next question. She says, in the literature of incest, does there appear to be generally accepted within the research community the notion that incest perpetrators often go to a period or so-called grooming of the victim child to gain their compliance for their sexual demands? Sustained. Is there even an objection? So what I was trying to show through it that is that contrary to what may be common misperception, incest does not ordinarily start out as violence and are, but develops along an escalating pattern that begins with grooming and seduction behaviors to get the child's cooperation, pledges of secrecy, and as the child gets older, threats in order to secure their continued silence and cooperation. I mean, that could have been done in 1 or 2 questions, but for all the objections, and it isn't even necessary if I am pursuing, in my opinion, this course of showing what the literature shows are common patterns to even ask any linkage questions. Is that what Erik Menendez told you? They heard it. The court says, okay, anything else? Court says, oh, sorry, Mr. Khan says, yes. When I indicated a year ago that, under some circumstances, the defense should be permitted to present expert testimony to rebut the common misperceptions in a particular area. Hold on. He goes on to say, what I specifically indicated at the time was number one, it would be incumbent upon counsel to demonstrate to the court that there are particular misconceptions that need to be rebutted. The way you do that is by specifying what are those specific misconceptions that she wishes to rebut through the expert, identify those misperceptions to the court, can so that the court can make a determination if they are in fact misperceptions and if they need to be rebutted. Counsel now thinks that she can get in everything under the umbrella concept without making an offer of proof. When we look at what it is that she's offering, it is not common misperceptions, it's profiling evidence. So it has nothing to do with what I said a year ago, that there are some common misperceptions that may be admissible. You may also remember that the court asked at that time if I saw any common misperceptions that applied to this case, and I said I didn't see any, I would submit it. Ms. Abramson says he doesn't see it as a misperception because Mr. Khan is so married to the notion that if my client was abused, he would have run away. Mr. Gessler says, may we confer for a moment? The court says, we can take a short break. I want to look at that case and we will start again in a minute. So they take a break. I think that's a really good point that Ms. Abramson just made, is that these misperceptions, he's not even seeing them as misperceptions because he just thinks, oh, they weren't abused. So he doesn't even understand that they're misperceptions. He's the one that needs to know. He's the one that it needs to be explained to. People like him that don't even understand that they are misperceptions. That makes sense? So there was like a perfect answer, I thought. Anyways, so we come back from a break. The court says we're resuming anything further by either side. Ms. Abramson says, not at this point, Your Honor, but there is another issue I want to take up with you. The court says, what's that? Ms. Abramson says, well, apparently, and I don't unfortunately learn about it until last night or see the documents until this morning. Last Friday, Mr. Khan handed Dr. Wilson on the witness stand within his courtroom a purported subpoena ducis tecum directing the witness. I don't have a copy. People never gave me a copy or a notice of this, and I have never been told that they filed no proof of service, as indeed they couldn't have under the circumstances, but directing the witness to produce 2 things. all his original notes, I'm not sure what that encompasses. And secondly, everything, all documents, and I am trying to remember it, reports and documents, I'm not sure of the language, provided to the witness by defense counsel. Our position is that that is not legal service, and apart from not being legal service, that is way too broad. Court says, okay, as far as not being legal service, what is your argument? Ms. Abramson says, my understanding is that you cannot serve a witness with a subpoena inside of a court of law. The court says, well, assuming that is accurate, all he has to do is wait for him to walk outside the door. So it's not really, Ms. Abramson says he didn't even wait for him to walk outside the door. Court says that really wouldn't accomplish anything by that argument as to the merits of it, and it doesn't have to be done by a subpoena. It just has to be done by asking the witness the first question on cross-examination to produce whatever it is that they have relied upon in your opinion. Ms. Abramson says relied upon is not what he subpoenaed, what the subpoena asked for. So he asked for everything, not just what he relied upon, but everything that the defense gave him. The court says, I'm saying that the question has to be asked, and the witness will be required to produce all of that stuff and not hide behind some mechanism that there is too much to bring or didn't bring it because I forgot or whatever. Ms. Abramson says, frankly, the way when you know you have an out of state witness and you have a case this enormous, and he has recited on the witness stand the amount of materials he was given, it is a matter of courtesy to communicate to counsel or to communicate to the witness that he would like to see the matters upon which he relied. The court says the people did that before the trial started. They filed all sorts of motions and subpoenas and things. How do you know that they filed it for this particular witness? You don't know that. They gave you adequate notice of what they wanted, and I told you that it would have to wait until the witness came in and testified. So you were on notice of that. This is not a surprise. Ms. Abramson says they have been provided with absolutely everything he relied upon anyway, and I made that clear all along, and he made it clear in the interview he gave, and they have all the same information he has. There is nothing that was withheld from the prosecution that the witness was given on purpose. The court says, well, this is certainly subject to inquiry by the prosecution on cross-examination as to exactly what it is that was turned over and relied upon by the witness. So what I am going to do is unless I hear something from the prosecution, I'm going to wait until cross-examination at that time, which the people would be entitled to request that information. Ms. Abramson says that's the information that he relied upon. Is that correct, Your Honor? The court says that's the law, that they are entitled to anything that he relied upon. Ms. Abramson says we will have that available for cross-examination. Mr. Khan says this is like the subpoena duces tecum just means like we want you to turn something over. So they want everything that he was given by the defense apparently, or that he relied upon, one or the other. I don't know which. Ms. Abramson says we will have that available for cross-examination. It seems only the things that he relied upon. Mr. Khan says, I would also indicate that while the people are entitled to examine what the witness relied upon, I think that the way that the rule is normally formulated is that relied upon versus materials which he did not rely upon or consider, and we are not asking him to provide us with or to even discuss theories or literature that he did not rely upon. However, it's my understanding, just based upon the interview, that he that we had the interview that we had with Dr. Wilson, that perhaps there were materials that were submitted to him by counsel that in which he was chosen after considering the material not to rely upon. So I think that a legitimate area of examination is whether there are additional materials which were submitted to him and which he made a decision not to rely upon, because if the rule were simply that he could rely or could only examine him in regard to the materials submitted by counsel which he relied upon, then of course he would pick and choose and take out everything That doesn't support his opinion, and divide all the materials into two stacks and just simply refer to everything that supports his opinion and never be cross-examined, and avoid cross-examination on all the material submitted to him which he is aware. What the hell is this guy talking about? Ramble, ramble, ramble. Which he considered, which contradicts his opinion, but which he is saying, well, I simply didn't rely upon it, therefore I don't have to produce that or reveal that in any way. So I think that the witness should be prepared to demonstrate on cross-examination material that was submitted to him by counsel. So they do want everything that he was given, despite whether he relied upon it or not. The court says, all right. Ms. Abramson says, I don't know a case citation that says that's appropriate. If there is, I haven't heard it yet. The court says both sides should provide the court with the authority for those questions, Mr. Khan, before you get to it and prepared for it. Okay, let's deal with issues here. So the parties referred to Eris and discussed its various holdings and the language of it, and it's correct to say that the evidence offered by the defense in this case is different than that offered in a case where the diagnosis is that of most mental disorders or diseases. Just as an example has been put forth by counsel, a diagnosis of schizophrenia as a basis for expert testimony about a mental state at issue in a case. It doesn't require testimony about the cause of the schizophrenia or the background of the individual that led to the schizophrenia, as long as there is documentation and an adequate basis for the expert to form the opinion that the patient suffered from schizophrenia. The symptoms meet certain criteria recognized and accepted in the psychiatric and psychological communities. Oh, my stuff just fell. Whoops. In the case before the court, there are additional features that come to play because the expert witness called by the defense testifies in his testimony that, or will testify, that the defendant suffered from a particular syndrome. That diagnosis is based upon a clinical examination of the defendant, supplemented by reference to his history. His history is utilized to ascertain whether or not a particular cause resulted in the diagnosis of, and I use the word syndrome, but the DSM uses the word disorder, that a particular stressor caused the post-traumatic stress disorder as diagnosed. The issue here is not whether a particular stressor caused the disorder. The issue is whether the defendant had the disorder at the time relevant in this case. That's what the Eris court was talking about in language on page 1199 when it's distinguished the Bledsoe and Bowker case from the facts of Eris, because in both Bledsoe and Bowker, the issue was whether the individual victim had been AR'd or had been subject to sexual abuse. That was the ultimate issue to be ascertained by the trier of fact. In Eris, the ultimate issue to be determined by the trier of fact was the effect of battered women syndrome on certain mental processes of the defendant at the time of the crime. It is clearly a subsidiary issue for the trier of fact whether and what caused the individual to suffer from this syndrome, because that is not why that evidence was being introduced. The why of the syndrome wasn't the issue. The effect of the syndrome was the issue in Eris, and that is the situation in this case. Okay, dog. He keeps moving around. This is not so much why did the defendant have a diagnosis of post-traumatic stress disorder or why did he have a diagnosis of battered person syndrome. The issue is what that effect did. Sorry, let me reread that again. Sorry, I'm distracted here. The issue is what effect did that diagnosis have on him at relevant times in this case? The defense is expanding on the relevant time in this case to include not just the time of the actual killing of the parents, but also the effects of the syndrome on the defendant's conduct at early times, is not leaving the home to refute the prosecution's allegations or arguments brought forth in their cross-examination. The case before the court is complicated to some extent beyond the fact situation of Eris by the allegations of sexual abuse, which are alleged to be one of the stressors that produce the post traumatic stress disorder, but also the allegations are alleged to be the linchpin of a defense version of what occurred at the time of the killings. This allegation of sexual abuse was the catalyst for all the events that occurred the week preceding and at the time of the killings. Therefore, independent of the issue of whether or not the defendant suffered from post traumatic stress disorder, which caused certain effects upon his mental process at the time of the killing, a significant issue in this case is whether or not he was actually sexually abused. That becomes a critical issue at this time, and one that can't be analyzed along the lines of it only being the basis for a diagnosis of post traumatic stress disorder. It factually is distinguishable then from Aries in the regard one could argue in Aries, well, it was significant that she had been beaten by her husband, and the fact that there was evidence brought out by the proposed testimony of Dr. Walker in Eris that Mrs. Eris was a battered woman, and the fact that she was a battered woman might have had impact on her provocation and state of mind at the time of the killing, which, even though the Court of Appeal did not regard it as sufficient to justify a finding of imminent danger, still could be considered. The fact of such abuse could be considered perhaps by the trier of fact on the subject of heat of passion to reduce it, if not from murder to manslaughter, to reduce it perhaps from the first degree to second degree murder. It is certainly a byproduct of testimony that Mrs. Aras was a better person, that the jury would then take that evidence into consideration in determining whether or not because she was battered that there was provocation or whether else that or whatever else. But this is like the exact same thing, the exact same situation. So she was battered, and that came into her trial because the jury needed to decide. Blah, blah, blah. My tongue is not working. The jury needed to decide whether or not this Miss Aries is a battered spouse, battered person. And in order to do that, they had to look at different parts of their relationship, I'm sure. Anyway, so he says, or whatever else that they could consider for the purpose of deciding the level of culpability. But that is, from my view, a far cry from the factual scenario in this case. It's exactly the same. Were they in fear? Was their state of mind in fear because of the abuse that they suffered their whole lives? It's the exact same situation. They're battered people. They're not a spouse of Jose. They were Jose's and Kitty's kids who very much so were abused by both parents. But that is from my view a far cry from the facts in this case. As I said, the sexual abuse of Erik being the catalyst in the defendant's version of the events of that day and that week. Bear in mind, that's not it at all. Bear in mind all of this testimony, all of the issues related to all this depend upon reliance on the defendant's version of what happened the week of the killings and at the time of the killings. The people have a different version altogether as to what happened and don't rely upon the defendant's version, or if they do, they rely upon it for very different purposes. And we're now dealing with the defendant's version of what occurred. The remarks I have just made basically are a reflection of the arguments here that have been presented as to what evidence can be received from the expert to buttress his opinion. Number one, that the defendant suffered from post traumatic stress disorder, and number two, the effects of the disorder upon his mental process at the time of the killings and perhaps at some other relevant times. Yesterday, in the proposed testimony of Dr. English, the defense sought to introduce his opinion that Erik Menendez had been sexually abused. That question was asked of Dr. English and by Mr. Levin, and the defense position was that that's a standard question that should be permitted. It's always permitted and should be permitted in this case. From the foundation that had been established preceding the question being asked of Dr. English, it was quite clear to me that that is not an opinion that the witness would be permitted to express. If you remember, they had Dr. English on the stand very briefly, then they went off the record. Even the um, even the transcript was, off the record. The pages were blank, and we didn't get to see what or hear what their conversations were about those things, about this abuse being, what they didn't get to talk about Carrie English. We didn't hear what their conversations were about Carrie English. And then all of a sudden we're back and it's a different witness on the stand. We didn't even see them get sworn in. So there was a bunch of stuff that happened that we didn't get to actually learn about, or, weren't, you get it. So I think you do. So from the foundation that had been established preceding the question being asked of Dr. English, it was quite clear to me that that is not an opinion that the witness would be permitted to express. This is the judge talking, by the way. So he's saying the Eris case and the Menendez case are different. He's seeing major differences in it. He said, even though I think it's the exact same thing as a battered person versus a battered spouse, what the hell is the difference? This guy says, no, because I think he's supposed to make sure that they get their conviction, because the LA county's office was made a laughing stock when this first went to mistrial. The Rodney King beating happened somewhere in this time frame too. That might have been first. Then Menendez. You guys can correct me if I'm wrong, but there was a lot of things going on. There were LA riots. A black man was beat up by police officers in the street, Rodney King, and that was a big deal back then. And um, this trial, the mistrial. Then, of course, you have O.J. Simpson, who was acquitted in his trial, and the DA's office looked like a laughingstock for some of the things that they did, unfortunately. And then the Menendez brothers retrial happens. So they really needed a win at this point. The LA County DA's office really needed a win at this point, because it was loss after loss and just bad image after bad image, high profile cases that made LA look really bad. And they took that anger or whatever they were feeling about all of the things that made LA look bad, and I think they put it on the Menendez brothers because they could. Because why not? Anyways, so from the foundation that had been established preceding the question asked of Dr. English, it was quite clear to me that that is not an opinion that the witness should be permitted to express. There was no foundation for it other than the consistency of a particular physical observation in 1977. Was it consistent with sexual abuse or consistent with non-sexual abuse, and basically nothing else other than that defense then sought to introduce the opinion of Dr. English that he interviewed Erik Menendez, and Erik Menendez told him a version of events that was consistent with the sexual abuse victims provide, and therefore, in his opinion, Erik Menendez had been sexually abused. That was basically what the offer was by the defense, and it was subject to objection, and the court sustained the objection. It seems to me that basically what the defense is offering here today is the same thing through the testimony of Dr. Wilson, that in his opinion, he has analyzed this version of events described by Erik Menendez and concluded that he was sexually abused. The defense says it will not offer that opinion and stay away from that opinion, which would be clearly inadmissible. The defense, however, argues that it should be permitted to present profile evidence of how particular sexual abusers behave to buttress the defendant's version of the events and his credibility, and also to dispel the common misconceptions of how abuse occurs. And the common misconception that was articulated here was that abusers suddenly and without notice in family situations violently sexually assault their victim, and the defense wants to disabuse the jury of that particular misconception. One wonders if that really is a misconception that needs to be disabused. Are you kidding? This guy is such an ass. It doesn't really seem that it would have to be under the any rational analysis of the situation that in a family situation, I don't think the average juror would expect that molestation occurs by sudden violent acts of aggression, but that they occur over a period of time. So, as far as that misconception, I don't see how the evidence occurred by the expert is helpful because there is no misconception. So, what misconceptions are there what can be characterized as profile evidence, which it is, of how certain people generally behave in certain circumstances? What misconceptions are there that the defense wishes to dispel? Ms. Abramson says, I will answer that directly in a moment, Your Honor. But that evidence was not only to dispel common misperceptions, but to just, as Bowker said and Bledsoe said, when the victim's credibility, and my client is the victim in this case, in this analysis is attacked, then theoretically evidence should be admissible to show that the statements of the victims are assume X, Y, and Z is that consistent with the behaviors reported by other abuse victims. Assume Q, R, and S that is consistent with behavior reported by other victims. Even in the prosecution cases, the child sexual abuse accommodation cases, a term we are not using in this case, indicates that that kind of questioning is admissible. So, it was being used to show that the way in which Erik Menendez described this period of time, this 5-year period of time, when he was told that this was love and this was attention and this was normal and it wasn't painful and his father was always nice to him, and then how it changed into escalated violence, and then there were threats, and then there was silence, and all of that is consistent with the body of literature showing how incest perpetrators enmesh and ensnare and seduce their victims. That doesn't require the expert to say, I believe this happened. It simply indicates that it's a consistent pattern to bolster my client's credibility, which is an appropriate use when his credibility has been attacked to show that at least if he's making it up, he has one heck of a grasp of the literature, which no one has ever shown was made accessible to him. Now, there are many areas in which I think that would be appropriate questioning in hypothetical form. If that's the way we have to do it, fine. All I am trying to do is dispel the notion Mr. Khan is trying to plant to show that Mr. Menendez made it up out of whole cloth, and if he did, he made it up things that appear in the literature over and over again and not in the pop literature. And I think that is appropriate to support his credibility. She's right. She's absolutely right. That's a great point. Showing that his memories or his stories, his versions of whatever, of abuse that he's saying he endured are very consistent with other people who have been abused. So it is one of those things that it kind of gets I totally lost my train of thought. Sorry. That it's not that he wouldn't know those particular things to say them, because if he wasn't abused, he wouldn't know the literature, the actual educational literature of what it is like for an abused person. Just as the Bowker court and the other one I read that talked about the same concept, the most recent case that they cited also talked about the same concept. But with respect to the common misconceptions in that sense, generally, I am talking about the same kind of things that the Iris or the Eris case was talking about, and that has to do with another theme that the prosecution played on, which was whether abused people would leave. The concept of learned helplessness, which we haven't even talked about yet, why they don't run away, and the same sense that battered women don't just up and leave. The court says, okay, that's a byproduct of the conclusion that the defendant suffered from post traumatic stress disorder. Are you freaking kidding me? No, it's not. It is, but it isn't. Like it's part of the problem. And if you don't understand that, that's a misconception that needs to be laid out to the jury and to you, court, even though you sat through a trial already and watched this happen. I hope he's really hot and sweating and burning wherever he is, because I think he legitimately tried to put these boys away for life or even the death sentence. I don't know. So Ms. Abramson says, and battered persons syndrome. The court says, but we are now talking about sexual abuse. That's a different issue. Ms. Abramson says, well, except that the same is true of children who are being sexually molested. I don't want them excluded from that group of people who don't report, and particularly sexual abuse is the most underreported form of child abuse. The court says, that basically says, Mr. Expert, you have concluded that this person was suffering from post traumatic stress disorder or battered person syndrome. In that situation, hypothetically, in a hypothetical sense, do these people leave the battering situation? It doesn't have to do with a finding of sexual abuse or anything else. It has to do with just the byproduct of finding a person to have been a battered person suffering from battered person syndrome and post-traumatic stress disorder. You are using sexual abuse in a different way and as a basis for finding that that the defendant has been sexually abused. Ms. Abramson says, no, I am not asking for this witness to offer a finding as to whether the defendant has been sexually abused. I mean, that's incorrect. But, and with respect to the common misperception about not leaving and not reporting and not becoming used to trauma inducing behaviors, those are the common misperceptions that I intend to ask him about having to do with abused people. They don't necessarily have to be people suffering from post traumatic stress disorder. However, what they have to be suffering from is learned helplessness. We need to get back to that. She needs to get that on the record, this learned helplessness, which people can suffer from when the court says, well, I think it has to be restricted to someone who has been diagnosed as suffering from post traumatic stress disorder or battered person syndrome. Somebody who has been diagnosed as the defendant has, not others in other categories. For the purpose, this is the defense proposed expansion of the use of the battered person syndrome or post traumatic stress disorder beyond the focus of the mental state at the time of the crime, but to explain other conduct. As such, and Eris said, it's admissible. But that's a separate issue from talking about the act of R, or sexual assaults syndromes. And things of that sort. You are mixing up all sorts of different concepts. I think the judges. Ms. Abramson says, but I'm not talking about R syndrome or sexual assault syndrome at all. We are not talking about the child abuse accommodation syndrome, for example, was not a syndrome that describes the psychological effects on children of the crime of sexual assault. That we submit is not an accommodation syndrome, but is a battered person syndrome or a post-traumatic stress disorder if he gets that bad. The problem with child abuse accommodation syndrome and the R trauma syndrome, too, is that it did not look at the psychological effects then demonstrating themselves into the symptoms of the mental disorder that was caused by the trauma. That's what's wrong with those syndromes. And the disorder or syndrome we are talking about here is a completely different type. Those syndromes came up as basically excuses to explain certain behaviors by our victims, and some are victims who demonstrated them, and by molested children having to do with such things as why do molested children recant their stories? It has to do with basically post crime behaviors having to do with when there is intervention, like an abuser says, if you rat me out to the cops, I'll kill your family, or something to that effect. I'll kill everyone you love. The court says, right. So Ms. Abramson says, and that's not what we were talking about here. I am talking about effects from molestation, how the effects of how these are characteristics in the molestation that cause effects on the child, psychological effects that demonstrate themselves in symptoms, as well as psychological effects based on the nature of the trauma that demonstrate themselves in behavior or the lack of behavior. So I submit to the court that it was very different to talk about a diagnostic syndrome, which is when battered person syndrome and post traumatic stress disorder are, and a so called syndrome such as child abuse accommodation syndrome, which really has no diagnostic or clinical value. The court says, all right, but you are now attempting to use the diagnosis of post traumatic stress disorder or battered person syndrome to establish that the individual was actually battered or suffered some other stressors. Miss Abramson says, no. Well, how is she supposed to get it in, Your Honor? Like, how is she supposed to get it in then? You're just not letting her put on a freaking defense. It's making me so angry. It's just, no, nothing with abuse can come in. I just don't want it because whatever, he makes up whatever excuses. It's like the goalpost just keeps moving every time. The court says that is not the basis of the court's ruling for its admissibility. The court started that. The court started that, or stated that if that was the offer, it would be rejected because there was no expert who can testify that because of certain, and this was documented during the hearing that we conducted, that because of certain clinical diagnoses, I can conclude that this person suffered certain stressors, such as I cannot conclude because someone suffered certain stressors that person will then later on develop post-traumatic stress disorder or battered person syndrome. Ms. Abramson says, I believe the second is true. I am not sure that I agree with the court that an expert can and in fact doesn't routinely, and I think anyone diagnosing post-traumatic stress disorder routinely determines what was the causative stressors, and they have to. The court says they take that based upon what the patient says. Ms. Abramson says, if what the patient says is believable, they don't if it isn't. The court says they don't need anything else. Just as Dr. Wilson, if he was dealing with a Vietnam or war veteran who came into his office and complained of symptoms and clusters of symptoms, that all those things that led one to a diagnosis of post-traumatic stress disorder, and say, gee whiz, what caused all this? And the man said, well, I was in the Vietnam War and I was in the Tet offensive. I don't know what that means. And this was what occurred to me. Dr. Wilson doesn't then go back and interview all of his fellow soldiers in the platoon to verify that for a diagnosis. Are you kidding me, Judge? So basically, he's like, psychology is not admissible in my court, even though it's admissible in just about every other court. It's not admissible in his court. Okay, got it. Whatever. Ms. Abramson says, yes, he does, if it's for forensic purposes. So a forensic therapist or psychologist or psychiatrist, forensic psychologist would do the background checks, the work, and go and double check things that this person is saying. The court says for forensic purposes, he might well do that so he can bring forth before the jury all the extraneous material that Ms. Abramson says no. The court says would otherwise not be admissible. The purpose of these diagnoses, if we look at them, is treatment. If there was a diagnosis for treatment, and if all he needed to treat that person and to determine what it was that the person was suffering, so that he could treat that person, he doesn't need to go through that history. Let me finish, because at that point, when you go in into the history, all you're doing is perhaps providing more documentation to buttress the diagnosis. But the bottom line is, does he or does he not have that diagnosis based primarily upon the clinical examination? And once you have that diagnosis, then the focus shifts to the only relevant issue in this case. What effect did that diagnosis have on that patient? He finally moved. I can finally come a little closer to the camera here. Felt like I was so far away from you guys. I think he needs to go out. Hold on. We're back. All right. So the bottom line is, does he or does he not have that diagnosis based primarily upon the clinical examination? And once you have that diagnosis, then the focus shifts to the only relevant issue in the case. What effect did that diagnosis have on the patient? Not why he had the diagnosis, not what caused it, not what was his history, but what effect did that diagnosis, did that symptomology, that syndrome have on his actions at a relevant time in the case? Ms. Abramson says, I have to disagree with Your Honor, and here's why. I disagree with you because factually, what you're saying is not clinically what happens with post traumatic stress disorder. Let me tell you why. It really doesn't matter what, quote, effect post traumatic stress disorder has on an individual at a particular period of time in the clinical setting. It's important in the forensic setting. The court says, that's what I'm saying. Ms. Abramson responds, okay, fine, but in the clinical setting, in fact, and this is based upon my discussions not only with Dr. Wilson, but with others who deal with all the stress disorders, that in fact the history is crucial. The explicit history of exactly what happened to this person is critical, not the buttress diagnosis, but to treat them. They need to know why. You need to know what people's triggers are. You need to know how to deal with the same repetitive, patterns in their lives. Dr. Wilson, because he has been doing this for as long as he has that very research file on precisely what platoons and what companies and what parts of the military were serving in what action in Vietnam and what kind of trauma inducing episodes occurred. And he does, in fact, seek out all the records. He has the military records, usually, of the veterans that can give him descriptions of precisely what the stressors were because he can't treat post traumatic stress disorder just based on the effects. You have to know the historical events to so that you can understand why they're reacting to certain kinds of cues that otherwise you will not understand. You won't understand why. A red balloon sets this vent off unless you know that a red balloon sets this vet off. That unless you know that during the part of the offensive that he was involved in, when the Viet Cong came over the hill, they were waving these huge red flags. You have to be, in fact, that fact specific because the effects of post traumatic stress disorder are very trauma specific. And as you'll hear, if I'm allowed to question him adequately about the cues that were going on with respect to Erik Menendez at the time of the homicides, such things as his description of Jose Menendez as a shadowy figure is extremely significant based on his history, and it will be tied to an aspect of the molestation as a cue. There are many others, and that's the only way that you can treat people with post-traumatic stress disorder. I help them figure out what the cues are and why they're setting them off. And they always have a trauma specific base. So in fact, post-traumatic stress disorder is not just a diagnosis that tells you, okay, now we'll make you feel better. One of the reasons why it is so very difficult to treat because you really do need a much factual material. You need as much factual material about the trauma itself in order to adequately treat people. And apart from this, Your Honor, is the problem that in a forensic setting is the DSM requires he has to rule out malingering. I am certain that all Dr. Dietz is going to talk about is malingering and lying and things like that. And in order to rule it out, there has to be a quality to the information that makes it worthy of his consideration. That's a great point because they're going to say he's just faking. They have to prove he's not faking. He's really fearful of these people, and you have to show why. And in order to rule it out, there has to be a quality to the information that makes it worthy of his consideration. And the most obvious way that it's worthy of consideration is if the story that is being told is consistently with the patterns of abuse and other people have told in the literature. I mean, that's the point, beyond the specifics of how the defendant reported it. Clearly, if the defendant's credibility is attacked, then Dr. Wilson's credibility is also attacked. His conclusion is meaningless if it isn't based on anything reliable to him. He has to deal with that as in order to be a competent mental health expert. The DSM directs him to deal with the issue of malingering, and we're going to deal with it. It's my intention to direct it's my intention on direct to bring out how he considered that directive in the DSM-4 in this case on the issue of malingering, and did he rule out malingering, and why did he rule it out? And I think it's perfectly appropriate to do that when that's a requirement. The other point here is that in order to diagnose for post traumatic stress disorder, unlike schizophrenia or other things, the DSM-4 directs him to testify or to identify the traumas. So you have to identify the traumas in order to diagnose him. So it makes no sense that they want these things out. The only reason they want it out is because it shows how terrified they were, what terrifying people Jose and Kitty could be. You cannot have a diagnosis unless you have the traumas for identification. By implication, and we don't have to go by implication, but by implication, that means he accepts that the traumas happened and the symptomology is buttresses that, not the other way around. Perhaps it's a circle. I'm not sure which end he stresses more. The fact of the matter is, because there are no witnesses ordinarily to sexual molestation, and the accusation has been made that my client has made it up, I can't think of any case or any rule of law that makes it improper for the witness to be able to answer a series of hypotheticals, and I don't mean forever, a few, indicating that the specific descriptions of behavior that Erik Menendez gave him or testified to, I can frame the hypothetical either way, are consistent with, just as the cases say we should be allowed to do, with the way it's been described by other children alleging molestation. Now, the fact that may buttress my client's credibility, there's nothing against the law. There's nothing against the law in buttressing the defendant's credibility. I should think it's probably done fairly routinely, and there's nothing that says an expert can buttress that credibility. Court says, okay, let me hear the people's response. Mr. Khan says, yes, part of the problem, I think, is counsel keeps jumping back and forth between the treatment considerations and the forensic purposes. And that's where she's blurring the distinctions. She says if something is legitimate for treatment purposes, therefore it is admissible in a forensic setting. She says, for example, history is important. Well, history may be very well important in a treatment for a treatment purpose, but that doesn't mean that the DSM takes precedent over the California Evidence Code or California case law. So, whether or not history is important in that treatment setting, the court is still guided by law, not the DSM. We keep getting back on the issue of can an expert give an opinion regarding the stressor where the stressor is the key issue in this case in dispute? And he can give a basis for that opinion and can be present criteria by which that determination may be made in a treatment setting. And while that criteria may be legitimate in a treatment setting, while it may be reliable in the view of many, it doesn't make it reliable and admissible in a forensic setting. So, an expert can, in a treatment setting, rely upon hearsay statements of the defendant. He can rely upon all sorts of unreliable material and unproven theories in reaching a conclusion concerning an individual. But that doesn't mean that just because he does in a treatment setting, that he can present those conclusions in court. We're bound ultimately not by the DSM as far as the admissibility of evidence, but by Bowker and Bledsoe. But isn't the point of an expert to say, well, this is how I came to my conclusion? I conclude this. And the reason I conclude this is because A, B, C, D, E, F, why is he not able to say what A, B, C, D are? That makes no sense. Counsel argues that the DSM directs him to do this. It directs him to consider certain things. It directs him to consider malingering and to rule out malingering. Once again, whether or not the DSM directs him to do it, we have to look to California case law. So I would submit that what counsel seeks to do is to avoid the rules of Bledsoe and Bowker by simply saying that in a clinical setting, the expert needs to rule out malingering based upon unproven criteria. He may very well rely upon that criteria in a clinical setting. However, he should not repeat to this jury the unproven criteria as a basis for his opinion when the courts of this state have ruled that such criteria is inadmissible. Ms. Abramson says, I think if that's the people's position, the people should be prohibited from raising the issue of malingering whatsoever with the witnesses or questioning this witness's reliance upon things my client said or challenging the witness's credibility and make no reference to that. And then we would indicate that we want the same rule with respect to Dr. Dietz talking about truthfulness or non truthfulness or malingering or anything like that. Court says, okay, let me see if we can resolve this. Ms. Abramson says, I hope so. The court says, with the understanding that issues will arise during the actual questioning of the witness, there is here a blurring of different issues. The diagnosis of post traumatic stress disorder or battered person syndrome, to repeat, is only relevant on the issue of mental state at the time of the crime and to whatever extent the court permits it at other relevant times at issue brought into play by questioning of the defendant as to why he didn't leave and the effects of battered person syndrome or post traumatic stress disorder on an individual as to why that person doesn't leave the battering situation. That's the purpose for the admissibility of the evidence. There's a secondary issue here, and that is the basis of the expert's opinion. I agree with the prosecution that the court is not bound by the DSM in ruling on the admissibility of evidence. The court is bound by the rules of evidence of this state. However, the defense is entitled to establish the credibility of the expert opinion. I can just be present in the it can't just be present in the abstract. The people recognize that expert would be permitted to testify to post-traumatic stress disorder or battered person syndrome based upon the court's ruling, and by doing so, the stressors documented circumstantially would be verified by the witness to the extent that his testimony regarding the diagnosis is believed. I'm concerned about the use of the so called profile evidence, which it is, about how battered persons behave and how batterers behave. Not the battered person syndrome or post traumatic stress disorder syndrome, but in a sexual abuse situation, which is really what it is. They're separate issues here. A child is sexually abused, and that could create in certain children the effects that are diagnosed as post traumatic stress disorder. But at the same time, during the time the child is being abused and thereafter, that child can exhibit what is described as child sexual abuse accommodation syndrome, which is a separate issue altogether. And that's really what the defense is profiling here, is something different than the effects of being diagnosed as a post-traumatic stress disordered individual. And really the defense is sort of combining things and accumulating different things for different purposes into one witness's testimony. What I think must occur in a situation such as that, to the extent that the prosecution, in its cross examination of the defendant and of other witnesses, has brought forth questions about credibility of the defendant's reports of sexual abuse, the defense is entitled to buttress that in the same way as the prosecution is entitled to buttress the claim of sexual abuse by introducing in rebuttal evidence of child sexual abuse accommodation syndrome and things of that nature in its rebuttal in a prosecution for sexual assault. That is done in a general sense, in a general hypothetical. It's not fact specific, not tied into the facts of a particular case, not saying, well, assuming someone was a certain age and his father was a certain age and the father had this physical characteristic and there were candles placed around the room and a mirror over here and something over here. Do you have an opinion as to whether or not something happened? That would be fact specific and would be inappropriate, and the witness would not be able to testify to things other than in general sense to corroborate the testimony of the defendant after he's been attacked. But it has to be separated from the post traumatic stress disorder testimony because it's different. Ms. Abramson says, okay. Court says it's really different. You seem to combine things together, but they really are different. To respond to the prosecution's argument that the defense has no obligation or entitlement to buttress the credibility of the expert in his testimony, reference to the case of Peoples versus Ainsworth in California is helpful. In that case, there was a multiple defendant prosecution and one defendant testified, put on a defense, and in doing so, it was a mental state defense and put on a psychiatrist to testify about his mental state, which tended to implicate the co-defendant in some fashion. In that case, the co-defendant, Mr. Ainsworth, contended that the doctor's testimony, psychiatrist's testimony, was a violation of the basic rules governing the scope and permissible subject matter of expert testimony. Specifically, that defendant urged that the testimony was little more than an opinion, that the co-defendant, whose name was Bales, was telling the truth, which was a matter not subject to expert opinion and within the province of the jury. And the Supreme Court said the contention is largely unmeritorious. In that case, specifically, the expert testified there is a quotation to questions and answers. Question: You indicated his initial attitude towards you was quite cooperative. Answer: He was fully cooperative with me. He did not seem to be reserved, to be holding back any description of what happened as far as he could recall it. I had no sense that he was feigning or trying to cautiously cover up anything. I thought he was as direct and straightforward as he could be with his ability to describe what happened. End quote. That was the psychiatrist testifying about his interview with the defendant or one of the defendants. And the prosecution was arguing in an appeal that it was improper testimony by the expert because the co-defendant had been convicted. Thirsty, sorry. My throat gets so dry when I'm talking. So the Supreme Court said this: Dr. Thompson's testimony was relevant to Bales' defense of diminished capacity, and Bales' extrajudicial statement was clearly admissible as relevant to the development of Thompson's diagnosis of Bales' mental state. The doctor's statement of his own belief that Bales was not intentionally lying or deceiving him during the psychiatric interview was relevant to the reliability of the doctor's conclusions. As the people point out, the doctor did not testify that Bales was in fact telling the truth, or his version of the events was more credible or more worthy of belief than that of other witnesses. While his testimony of Thompson may have intended to enhance the credibility of Bales' testimony, that was not the purpose of the psychiatric examination or the doctor's testimony. Contrast the situation where a psychiatrist is called upon to assess a witness's ability to testify truthfully. And it refers to cases such as the Ballard case. And then continuing, we agree that in such cases where the sole purpose of the psychiatric examination and testimony relates to the credibility of a witness, the psychiatrist may not testify to the ultimate question of whether the witness is telling the truth on that particular occasion. But it's an expert for that defendant. It's not. So the difference is that case, there was a co-defendant and you were violating that co-defendant's rights while they were on trial. This is totally a different scenario. So I don't see. Okay. Anyways, as the defendant concedes that was not the purpose of Thompson's testimony, that's the language in Ainsworth dealing with that specific fact situation as presented by what occurred in that particular trial. The net result of that is that when an expert testifies, he's entitled to establish some credibility for his opinion and not just express an opinion without any further bias. I don't read Ainsworth to stand for the proposition that a witness can testify that the interviewed is credible or believable or that he believes him. I don't think the Supreme Court says that or meant that It was talking about specific language that occurred in that particular case to the extent it was received before the trier of fact, but certainly the defense is entitled to introduce some of the evidence to corroborate the expert's testimony and the reliability of his opinions, and in doing that, is entitled to assess the nature of the account, how it was presented, including that the defendant suffered from post traumatic stress disorder or battered persons syndrome. So I believe the people overstate their objection there. The defense certainly is entitled to introduce some evidence along these lines. Yeah, but I'm sure you're going to limit it to buttress the expert opinion and to not permit the defense to do that would be in error in this case. Anybody else wish to be heard? Ms. Abramson says, no, I think I understand the court. I think I understand the limitations. The court says, what do you understand it to be? Ms. Abramson says, I won't go into so-called profile evidence. What I think I'll do is segregate the whole common misperception segment of my examination with him until after we've gone through all the post-traumatic stress disorder and learned helplessness and hypervigilance issues. So the court understands exactly where I'm going at that point. I can refrain from the particular line of inquiry that I was engaged in with the court. I believe was calling profile evidence. I don't have a problem with that. On the common misperception aspects, I want the court to know what I'm seeking to explore, that is, children not reporting abuse and the factors of why that is so, both in a PTSD setting and not also in a better person setting. Not leaving abusive relationships, whether children get used to abuse, so it no longer has deleterious effects or impacts. I had one other, okay, that repeated misperception, that repeated exposure to fear makes you fearless. And that's the 4. I think I did that one already, but I can. Okay, anything else, says the court? Ms. Abramson says, uncommon misperceptions? No, says the court. Ms. Abramson says, maybe just a sort of obvious one. Boys do get sexually molested. The court says, other than that, as to personal beliefs of the witness. Personal beliefs, says Ms. Abramson. The court says, as to believing the defendant. The court says, I have no intention of doing that, Judge. Okay, says the court. Jackass. Ms. Abramson says, I didn't do it last time. I had no intention of doing it this time. The court says, all right. Ms. Abramson says, I don't think it's appropriate. But I do intend to ask him what was the manner and nature of the way the information that was reported to him that he found significant, and that would be similar to what Ainsworth, the kind of recitation that we heard from the witness in Ainsworth. Court says, that's admissible. That's what the Supreme Court says. Ms. Abramson says, okay. Mr. Khan says, I think what the court has addressed probably comes under category 1 of the motions that I filed under the heading vouching for defendant's credibility. But as I understand it, while the court has ruled that the witness may testify that he saw no reason to challenge the credibility of the defendant, that is, that the defendant did not appear in any way to be lying to him, that is a separate and distinct issue, and I understand the court from profiling evidence and whether the expert can give criteria, which still gives back under the heading of Bledsoe and Bowker. I understand that what counsel is saying. Counsel is not going to get into profiling evidence. She is not going to get into turd, which is inadmissible under Bledsoe, and I don't know what they wrote there. She said she has various common misperceptions that she wished to rebut. Because she hasn't advanced those questions yet, I'm still not exactly sure how she's going to advance those questions. The court says, okay, have you just addressed that issue, Ms. Abramson? She says, I could have sworn I did, Judge. The court says, all right. Ms. Abramson says, as far as criteria is concerned, I don't know what every examiner has criteria, but how they gather information and what they do with it. I think what the Ainsworth witness was testifying to was his criteria. When someone is direct and straightforward, that's one of his criteria. When he does not detect a sense of someone is feigning something, that's one of witness's criteria. I never heard of a rule that says I can't use The court says, clearly, an expert can say, I used my own standards in evaluating the witness as far as his credibility and briefly describe those standards. I don't see how a jury could evaluate the credibility of an expert without having some foundation. It wouldn't make any sense. But these are not truth-telling standards that an expert should be permitting to say. These are recognized standards, and this is what's used throughout the scientific community. And if a witness passes the test of these standards, then that witness gets a stamp of approval. That would be improper. I agree, says Ms. Abramson. The court says, let's get the jury over here. 5 minutes only. I want everybody back here at 10 minutes after the hour. Yikes. Okay, so breaking that down, some stuff's coming in, but some stuff's not. Basically, the expert will be able to get into things, but not in a specific sense. They can't talk about specific instances. They can't talk about why they die, the specific traumas that happened in Erik's life that he diagnosed him with PTSD, but he will speak in generalities. And that's what the court is asking. And of course, he can talk about his own standards and the way that he reviews and analyzes things and whatnot, but he can't specifically or explicitly say that I believe Erik is telling the truth or that I believe Erik was abused. Those two topics he's really got to stay away from. You can't say I believe this person is, feigning or he's a doctor. So he obviously has the ability to decide whether someone's feigning or maligning or whatever you want to call it. Doesn't necessarily mean he's right, but he has the experience and the authority to make that decision based on, what he's looking at with the patient's records. So I think he's going to be able to get into that slightly, but not too much. It seems like they're really putting a hold on the defense here when it comes to this expert. And usually when you hire an expert, especially a mental health professional, you want them to be able to talk about specifics about your case, because that's how you're diagnosed, as Ms. Abramson eloquently told the court. For PTSD, you need to talk about the specific traumas in order to diagnose and to treat. So you can't get from A to B to C without, going in the right particular order. And you need to know those traumas, basically, is what Ms. Abramson was saying. The court says, yeah, but only in generalities. We can't really go into it. So that's kind of where we're at. And I have a short stop. I think we might be able to get through this if I read fast. All right. So Ms. Nahara says, okay, so they come back from their recess. Oh, shit. I got to get water. Hold on. All right. We're back. Ms. Nahara is asking, could I put something on the record before the jury comes out? The court says yes. Ms. Nahara says, if I may, I've spoken to counsel for the defense and there is a problem we had, and as a result, we're not going to be able to do the interview this weekend. I told counsel about it. They have no objection to doing it next weekend. I've spoken to Les Zoller and he has no objection to it. The court says, okay, next weekend. Ms. Nahara says, next weekend. The court says, okay. Thank you, says Ms. Nahara. The court says, let's get the jury out, please. The jury enters the room. That was the Dr. Dietz interview that they were talking about, that the state wants to put Erik under a psychiatric evaluation for some reason. Court says the jury is in court. Good morning. And we're now ready to resume with the testimony of the witness, Dr. Wilson. Would you state your name? And he does. He's sworn in, blah, 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 blah. Ms. Abramson says, Dr. Wilson, since you were last here, did you go back to Cleveland to your teaching duties? Yes, I did. We haven't. You came in on the last plane out of Cleveland last night. I sure did. Before the airport closed, and we haven't had much of a chance. Do airports close? I don't know. I'm from Chicago. O'Hare's open 24/7. When do airports close? Anyways, we haven't had much of a chance to review. Mr. Khan says, objection irrelevant. Motion to strike, Your Honor, what counsel has done and not done. The court says overruled. Your next question, please. The court says, thank you. I believe we were still going down the symptom chart. Let me just look at, I find the DSM hard to read. Okay. We were talking about post traumatic stress disorder. We had been going down the symptom clusters list and also cross referencing it to hypervigilance. Would you explain the significance of hypervigilance in a diagnosis of post traumatic stress disorder? Yes. Hypervigilance is one of the symptoms of post traumatic stress disorder that develops after the trauma, but usually isn't present before the trauma. Hypervigilance, referring to excessive scanning of the environment for cues of threat or harm. Often the hypervigilance is trauma specific in nature, but by that I mean the person is responding to situations or cues or people of certain kinds of symptomology. It could be a smell, a sight, it could be an object which has an association to the original trauma. And when they have the response to trauma specific stimuli, they often have this hypervigilant state where they're keyed up, excessively aroused, and on edge, and looking to see if something is going to happen to me now. Am I in harm's way? This is a kind of psychological response of hypervigilance. Well, what are you talking about? Psychological aspects of hypervigilance. I think on the chart we have up there that's entitled hypervigilance. We were talking about the fact that there are actually four kinds of responses or four different components to hypervigilance dealing with different aspects of the person. That's correct. And I think we had gotten to the third, which was called somatic, which is how the body responds. Yes. Ms. Abramson says an underlying concept of post traumatic stress disorder and hypervigilance and the bodily response. Is there a connection between that, layman? I guess call the survival mechanism and all of these things that we're talking about with respect to post traumatic stress disorder? Yes. If you could, what is the basic connection between the survival mechanism, as laymen understand it, and post traumatic stress disorder? The survival mechanism, really, in the most basic sense, refers to preparation to respond to danger, to threat, or to a situation where one feels at risk to be harmed. You're on edge constantly. It's a constant state of anxiety, or in some way feel terrorized or very anxious about what's happening. And so there's this. Simply put, there's a kind of an energization of the body. There's this increased arousal level to prepare to respond to the potential harm or threat or anxiety producing. Just thinking about this makes me on edge. And it reminds me of my experiences of abuse and being in a hypervigilant state. So I totally understand. Do you guys, does anybody watching understand or have these symptoms, hypervigilance? How do you deal with it? Is it a struggle? It's a struggle. Anyways, so there's that. Simply put, there's a kind of energization of the body. There's this increased arousal level to prepare to respond to the potential harm or threat or anxiety provoking situation or stimuli or cues that's present for any given reason at any given time after a traumatic experience. So you're on edge all the time and looking for things that in your environment that could possibly hurt you or harm you or whatever. We all have this survival mechanism. Sure, says a witness. And people who have not been traumatized also have it? Yes. And when the mechanism is triggered by a person's perception that something dangerous is going to happen, our bodies go through this automatic somatic response, don't they? Objection leading and suggestive. Rephrase the question, please, says the court. Ms. Abramson says, do ordinary people's bodies go through this somatic reaction to potential threat? Yes. Do ordinary people's minds go through these thought processes of, oh, there's danger, I've got to do something? Yes. Do ordinary people scan the environment in any ordinary way? Sure. When people, for example, are going to cross the street, are ordinary people vigilant? Some are, some aren't. Should they be? They should be, but they're not always. Well, do we look both ways? Some people do, some don't. Do we check to see if the light is red or green? Yes. Does the behavior of, for example, people or women in particular to not walk down dark streets alone late at night, is that a vigilant behavior? Mr. Khan says, objection, irrelevant. The court says, overruled. Let's get beyond these examples. You can answer the question. The witness says the answer is that may be an example, yes. Ms. Emerson says, when we're talking about people, however, who have been traumatized by threatening acts and then develop post-traumatic stress disorder, do they react differently? Yes. Do they react differently on all these levels that we've talked about, which, if I had good eyesight, I could see from a distance on the cognitive level, on the affective level, on the somatic level, and on the behavioral level? That's correct. And I think you testified earlier that you talked about somebody's idol, the idol screw being turned up. Yes. What was that reference to the general level of anxiety, fear, and anxiety that people with post-traumatic stress disorder experience? Yes. Do they experience that only when faced with a threat, or is that their operating level? It can be their operating level on a daily basis. And when people with that operating level then do perceive threat, do they react the same as someone without post traumatic stress disorder, or typically do they react differently? They tend to react more excessively with a more intense response to that particular situation or stimulus. Is there research that's been going on to try to determine, first of all, why they operate at this generally high level of anxiety and arousal? Yes, there is. Is there also research trying to figure out, talking about research into the physical systems of the body, why they react more excessively? Yes. Is there research that indicates that they also react quicker? Yes. Is the notion of hypervigilance tied to the notion that they react to things that wouldn't have significance at all to other people? Yes. What are those things called in post traumatic stress disorder analysis? Well, I would call them trauma specific stimuli. They're cues. Cues? Correct, says the witness. Ms. Abramson says, now, if you have someone, is hypervigilance that aspect of the person that makes them scan for these cues? Yes, it is. And do people who are hypervigilant, who are scanning for cues of danger, do they always perceive the cues accurately? No. Do they sometimes perceive them inaccurately? Yes. Objection vague as to who's they. Overruled. Do they also tend to perceive cues inaccurately? Yes. Is there research on interaction between extreme anxiety and stress and the ability to think clearly, to reason clearly? Yes. To perceive clearly? Yes. When people with post traumatic stress disorder, when they do perceive what seems to them a cue of danger, you've indicated they tend to react more excessively? Yes. Is there any research on whether having post traumatic stress disorder and in the process of perceiving a cue impacts the person's sense of imminency of the danger? Yes. What does that research indicate? This is important. The research indicates that when a person has post traumatic stress disorder and they're reacting to the perception of a threat, that their tendency is to act as if it's happening again and to engage in behaviors to try to terminate the threat. So that right there is why, it's a great reason or explanation as to why they killed their parents. When you say it's happening again, I don't understand what you mean with respect to imminency. It's happening right then? Yes, they have the subjective sense, they have the personal sense that it is about to happen to me again. This is about to happen now. It's the fear, in many cases, of the trauma survivor that the traumatic event is going to happen to them. What took place in the past is going to take place again right now, the sense of imminence that here it comes. It's coming to me right now. And that's where the anxiety and fear intensifies because they feel it's about to happen once more. Even if there isn't an objective indicator that, let's say, there is a cue, okay? hmm So cue triggers this hyper aroused state of terrible fear, okay? Says the witness. Well, even if the cue doesn't have a time code, in other words, the cue doesn't say when it's going to happen, they feel it's now? Yes. Objection vague as to who is they. Sustained, the answer stricken. Come on, dude. Like you're making her talk in generalities, and she can't even do that. This is ridiculous. I'm so infuriated for the Menendez brothers and the defense team for having to deal with this stupid judge and prosecutor. Ms. Abramson says, do people with post-traumatic stress disorder, when they receive or when they perceive a cue and react, are they typically sensing, even without any time indication, that the thing is happening right then? Yes, that's one reaction. And is there, in fact, even literature trying to understand why they go from cue to immediate threat the way that they do? Yes. Is there research now is there research that has determined to some extent which specific hormones in the arousal system of the limbic system, in their systems of the brain, might be responsible for these different components of how and why people with post traumatic stress disorder react the way they do, as fact, as they do? All of that? Yes, says the witness. Well, are they isolating which hormones and groups of neurotransmitters are causing the different aspects of their reaction? Yes, they are. And is there a recent book, in fact, that tries to state that the research on this is at the current time? Yes, there is. Am I holding it right now? That's the one. Neurobiological and clinical consequences of stress? Yes. From normal adaptation to post traumatic stress disorder? Correct. And the editors, Friedman, Charney, and Deutsch, are any of them actually researchers in this field? All of them are. Are they affiliated with any particular institution? Yes. What? The National Post Traumatic Stress Disorder Center in 2 different locations. Dr. Friedman is the National Director of the Post Traumatic Stress Disorder National Center in White River Junction, Vermont, and Dr. Charney heads the Post Traumatic Stress Disorder National Center at Yale University, which is a national post traumatic stress disorder center to study the relationship between post traumatic stress and brain function. And are they finding a relationship between post traumatic stress and brain function? Absolutely, yes. Is there also a research group at Harvard University? Yes. Who heads that up? Dr. Bessel van der Kolk. That's the one, the mind body connection book that I showed you guys I had. And has Dr. Vander, however you're saying his name, published extensively in the area of trying to combine the biological and chemical connections to various aspects of post traumatic stress disorder? Yes, he has. And is the research indicating that there are, in fact, chemical and biological changes in the body of people who have been exposed to traumatic stress? Yes. And is it showing whether or not these biological and chemical changes can explain some of the symptoms and behaviors that people with PTSD demonstrate? Yes. And are these biological and chemical changes produced by stress transmitters? It depends on the nature of the traumatic stress. When the traumatic stress is more severe, when it is longer lasting, when it's repetitive, when it poses a greater threat to life, those conditions seem to be associated with more chronic or lifelong post traumatic stress disorder. And in chronic and lifelong post traumatic stress disorder, there seems to be a permanent alteration in the neurobiological functioning of the brain as expressed through these neurohormonal substances in the nervous system. Has it been observed in clinical practice and research based upon clinical practice, which means treating people, that aspects of the research that the symptoms of post traumatic stress disorder are very, very difficult to get rid of? Yes. Is that or did that lead to the research trying to see if there was something biological and chemical that had changed in people? That's correct. Not just that their behaviors changed? Correct. And are they trying to think of various medication therapies that might realign the biological and chemical changes that have happened to these people? Yes. Does it make any sense to approach a person with post traumatic stress disorder and try to treat just the behavior in clinical therapy? I'm not sure. Objection vague and irrelevant. Sustained as to the form of the question. Ms. Abramson says, there are certain kinds of physical, or I'm sorry, there are certain psychological therapies not having to do with trying to teach anxious people or stressed out people how to relax. Objection, irrelevant, sustained. Ms. Abramson says, is relaxation therapy adequate for people with post traumatic stress disorder? Objection, irrelevant, sustained. Ms. Abramson says, has relaxed therapy been tested with people with post traumatic stress disorder? Objection, irrelevant, sustained. If there's biological or chemical change, do purely cognitive therapies that get people to talk about their problems or understand their problems, do they have a high degree of success? Objection, irrelevant, overruled. Dr. Wilson says some of the cognitive behavioral therapies do have a great deal of success with treating post traumatic stress disorders, and there's literature now that's looked at in the clinical trials applying cognitive oriented treatments to post traumatic stress disorder to help the patient find cognitive ways to reframe the meaning of what they're going through, a traumatic experience. Ms. Abramson says they won't subject so they won't be subject to cues any longer. Objection leading, sustained. Well, what's the purpose of that? In other words, cognitive means making them understand what happens? Yes. Well, narrowing them, understanding why certain things set them off? Yes. So triggers. Trying to get them to think and not let the thing just set them off? Objection leading, sustained. What does cognitive mean in this sense? Cognitive, Your Honor. Oh, sorry, that was the court that said that. So, cognitive, Your Honor, refers to a specific form of psychological treatment for anxiety disorders and particularly PTSD. Cognitive means specifically helping the patient who has been traumatized to engage in thought patterns to modify their emotional responses when they start to relive trauma, when they become hypervigilant, when they become overly anxious, when they become fearful or depressed. These are specific techniques to help them actually calm down and reduce themselves and not overact or to stress themselves in ways that are debilitating their abilities to do whatever it is that they're doing at that time. So, cognitive really specifically refers to changing thoughts and changing thought scheme to deal with a wide range of situations that might trigger an intensification of their PTSD symptoms. The court says, okay. Ms. Amerson says, so what's the relationship between the research in trying to find medications to change the chemical and biological alterations and the cognitive therapy? Objection, irrelevant, overruled, says the court. The witness answers, the relationship between the pharmacological approach to the cognitive? Why are people bothering to try to find out all the biology and chemistry if cognitive therapy works? Objection irrelevant, overruled. The witness says the reason we're looking for biological treatments for post traumatic stress disorder, that is, The use of medications to change the way the limbic system in the brain is functioning is because some therapies, such as cognitive therapy alone, are not sufficient to reduce some of the more biologically based symptoms of post traumatic stress disorder, such as sleep disturbance and hypervigilance and hyperarousal, irritability, outbursts of anger, and nightmares as well. So the idea basically put of having somatic or pharmacology administering drugs or medicine is an attempt to retune, if you will, the nature of the neurohormoning function in the brain and to change the brain chemistry to there's a more balanced brain functioning than that then tends to attenuate or knock out or stabilize these biologically based symptoms of post traumatic stress disorder. And the result of this is to increase stabilization of the condition. That was a very complicated answer. So it makes the people less symptomatic? Correct. Well, let me finish going through the PTS criteria in the DSM 4 with you. Is there anything more that needs to be said about hypervigilance to explain how it operates on someone who's been traumatized and believes that they are about to be hurt in some way? Yes. What else? The fourth component, behavioral? Yes. Would you describe what the behavioral component of hypervigilance is? The behavioral component is how the person reacts to the hypervigilance to scan the environment for threats. So, while they may have these other components of perceiving the threat, feeling anxious or fearful in a situation, the behavioral part is what do they do? What steps do they take to deal with their hyperarousal and hypervigilance once it's occurred? What are the actions they engage in? What are the significant behaviors in order to identify what someone is that someone is hypervigilant? I'm not sure what you're asking. How does hypervigilance manifest itself in behavior? What are the types of behaviors that hypervigilant people show? Again, they vary on the specific trauma a person has suffered from and the consequences afterwards. Well, let me stop you. When you were talking earlier in your testimony about the people in the hotel, yes, is that behavior that shows that people are scanning the environment? Correct. Okay. Are there also behaviors that are reactions to the threat that are typical of hypervigilant people? Sure. You previously said this morning, in fact, that they overreact. They can overreact. Correct. Well, they don't always. Not always. Sometimes they freeze. So, is freezing, when you say freeze, what does that consist of? Not moving? That's freezing, right? What are we talking? Or what about thinking? It can be an absence of thought. It can be one is so scared, so afraid that they go blank and they lose the capacity to think, to problem solve, to make good judgments about what alternatives they might have in that situation. They draw a blank. They get overwhelmed with the intensity of their anxiety. Concentration tends to wane. And in the opposite mode, if someone is not frozen but is overreacting okay to a perceived threat grave enough to cause such a reaction, what is understood about the cognitive or lack of cognitive process going on there as well? Well, there can be a number of cognitive processes. One is to misread, misconstrue a situation, to misappraise it, to read it the wrong way. That's one possibility. The person simply can be overreacting. They don't see that threat may not demand such a powerful response or intense response. So there's this misperception. Possible distortion is possible. By distortion, I mean both perceptually in how they see something happening, as well as distortion in their thinking. That is, how they're thinking about what's happening to them. Both of those are possible, whether they have a perceptual distortion, for example, where a bank teller sees a gun become huge in her field of vision, or has distortion in her thinking. Either one of those processes, the perception or the thought, will affect how they respond to the situation. And with respect to responding, when people who have been traumatized is it appropriate to use with the word triggers? That the cue triggers their reaction? Yes. When people who suffer from PTSD scan come upon a cue that triggers this response, you've described this as a sense of fear and terror and fear of death. It could be. And or fear of re-experiencing the trauma. Correct. And they believe it's imminent. Yes. And when they do act out in response to it, assuming they don't freeze, assuming they don't flee, assuming they do the flight part and or fight or flight, do they tend to overreact there? Yes. Is that overreaction the product ordinarily? Well, is it the product of a person who's in the hyper aroused state of calm, deliberate thought? Could you repeat the question? Is their overreaction a product of calm, deliberate, weighing thought? You're smiling. Why are you smiling? Because I understand your question now. The answer is no. I would object unless it's case specific. Overruled. The answer is no? Correct. What kind of thing is a person in this condition doing? Objection calls for speculation. Court says it's vague. Ms. Abramson says, all right, what's the level of thought process in a hypervigilant, post traumatic stress disordered, overreacting person? There are a number of possible thought reactions, but generally, the person has a sense that something horrible is about to happen to them. It's going to happen now. They often have a thought of fear or of terror or fear of impending doom of one type or another. That this bad thing is suddenly going to happen to them, and also associated with that thing or of urgency and intensity such as a feeling of, I better hurry up and do something. I better act in a way that will stop what's about to happen to me. Otherwise, they fear that a terrible consequence is going to take place. Now, you told us that you spent 30 and 1/2 hours talking to Erik Menendez. Yes. Did you spend a portion of that time talking to him and interviewing him about specific events on August 20th, 1989 and the week leading up to them? Yes, I did. And did he, in talking to you, convey to you what he was feeling and thinking and how he was perceiving and reacting within minutes of the shooting? Yes. Was the way that he was describing how he felt, both emotionally and physically, what he thought and what he perceived and how he reacted, consistent or inconsistent with the way people with post traumatic stress disorder react to the perception of extreme danger? It was consistent. And in talking with him, did you strike that? Apart from talking to him about the specific aspects of that night, August 20th, did you talk to him about the entire week preceding it? Yes. Did you go through each day with him? Yes. Did you also spend a significant amount of your time with him going over his life history? Yes. Specifically, the history of interactions with and relationships with his parents? Correct. Did you go back? Did you talk to him on several different days? Yes. Would you come back to the same topics on subsequent visits? Yes. Would you play devil's advocate with him when you were questioning him? I did. Did you challenge him? Yes, I did. Did you confront him? Yes. Did you cross examine him? Yes. Is that something you typically do when you're making an evaluation of someone for court purposes? Yes. And did you, in your own mind, try to determine whether there were cues that were explainable in terms of traumatic events from his past that he was reading on that night on August 20th? Yes. Based on strike that, you read, in addition to talking to Erik Menendez in person, you read his testimony from the first trial, did you not? Yes. And you formed your diagnostic opinion before he took the stand and testified in this trial, did you not? Yes. Did you also, however, read the testimony he gave before the jury in this trial? I did. Did you also read notes of the interviews that Dr. Vickery, a forensic psychiatrist, conducted with Erik Menendez starting back in 1990? Yes. Now, you testified that often what a person with post traumatic stress disorder is reacting to or overreacting to are cues that are trauma specific? Yes. What does that mean? The trauma specific cue refers to a cue, a stimulus. It could be a sight, a sound, a smell, a place that's associated in the mind with the trauma survivor with what they experienced originally. So they see some parallels or some similarities to that cue, that situation, that place, a particular person, particular behavior, an activity, a smell that they associate specifically with what happened to them in the trauma. That's the trauma specific cue. It's a product of learning in terms of what happened to them in the traumatic experience. So, like, I'm trying to rush here because I got to go pick up my boyfriend from the airport, and we're not going to finish, and I'm mad. I just have like maybe 10 more pages or something. But anyways, so we'll probably stop it right here. But this reminds me, so like an example, I'm going to give you guys an example. Let's say a child is being abused by, a family friend or whatever. And every time that abuse occurs, they take that kid out for ice cream, or they take that kid out and go buy him a new Lego set, or whatever it might be. Every time in their adult life they see Legos or they see ice cream or whatever it might be, they're going to be triggered by that thing because it reminds them of that horrific, traumatic time in their life. You know what I'm saying? Or let's say a belt, like the Menendez brothers got the belt. Things like that are going to traumatize them when they see a belt lying on a table, because that's what Jose would do to put fear in them. So those things can come up later in your life and traumatize you. And you don't even realize it, but it's there in the back of your mind, is always there. And it's going to trigger you. So I'm going to leave it at that. We're going to stop right here. I'm almost at the end of this particular section. We'll just, in the next episode, we'll just finish this day off from where I'm leaving right now because I got to go get ready to go pick up my boyfriend from the airport. He had to go travel for work. So I'm glad to have him back. Anyways, thank you guys so much for watching. Hope you enjoyed, and I will see you guys in the next one. Take care. Bye now. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.